In the case of Lampleigh and Brathwait, Brathwait, a murderer, asked Lampleigh to write to the king and ask for Brathwait to be pardoned for his crime. This was back in the 1600s. Lampleigh was successful in his quest. Afterwards, after Brathwait had been released, he delightfully promised Lampleigh £100 for his efforts. However, he never actually paid up. His reason for not paying is that his promise to pay came after Lampleigh had rendered the services to him. And as the infamous contract law rule goes, past consideration is not good consideration. In other words, where B makes a promise to another person, A, based on a past benefit that B had received from A, B is generally not bound by that promise. That being said, the Court of the King's Bench held in favor of Lampleigh, despite the fact that the consideration had indeed been passed. This was based on the doctrine of implied assumpsit. They held that there was in fact an implied understanding that a fee would be paid for Lampleigh's services, and therefore Brathwait was bound to pay Lampleigh the £100. In other words, the doctrine of implied assumpsit is an exception to the rule in past consideration, so that where a past benefit was conferred by A onto B, and at B's request, and it was reasonably expected that A would be paid in exchange for that benefit, B would still be bound by an implied promise to pay A. This is a quote from the judgment. Now, the English here is quite old, but the gist of it is saying that if Lampleigh had done the service voluntarily, here a mere voluntary courtesy, then that would not give rise to an implied assumpsit that would bind the promisor. However, as in this case, it was made at the request of the party, and therefore this gives valid grounds to argue that implied assumpsit had arisen.